Number 161293, Elaine Brown versus the United States. May it please the Court, the issue presented here in this case is not whether 924C 3B is constitutional or unconstitutional. The issue before you this morning is whether...
Counsel, let's not go off on a misdirection, okay? If we decide the prior case, and you were here for arguments, in the government's favor, what is left of your case?
I don't know what the predicate offense was in the case that you just heard. The predicate in this case was basically two.
You just heard the argument. Answer my question.
I'm sorry, Your Honor.
What's left of your case if we decide in the Douglas case that the categorical approach does not apply to 924B?
Because in her case, she has no, the predicate in this case is clearly not a crime of violence. I don't know what the predicate was in the case you just heard. But in this case, she's charged with conspiracy to interfere with federal agents under 18 U.S. Code 372 and 371. They clearly, those offenses do not have as an element the use of force, attempted force, or threatened force.
But why would it turn on elements of the crime?
Because the predicate in her case, how was the jury, I want to pick up on something that you raised.
Let me just help you out here. The prior case was a conspiracy to commit a Hobbs Act robbery. So it was a conspiracy charge, like the charge here, conspiracy.
But this is a different kind of conspiracy. The substantive offense is not Hobbs Act. The substantive offense is interfering with government operations, essentially.
It wasn't the interference with government operations caused by the use of munitions, guns, booby traps. Doesn't that sort of...
That was the evidence at trial. But
doesn't that sound like...
But the challenge here is, and I think that the court heard it, I don't know which of you raised it, the challenge here is even if you adopt the government's case-specific approach, you don't solve the Fifth Amendment problem. You don't solve the problem with the way Congress wrote the statute. Congress wrote the statute to say if an offense by its nature involves. That's the same language that the court considered way back in Leocal versus Ashcroft. And they gave, as the prior counsel argued, they gave a common sense meaning to by its nature. That's the ordinary case. It's not specific. The government, I don't think, can really talk its way around the way Congress wrote Section 924 C3B. And it's that language. And even if Justice Gorsuch did not join the other four on the other issues, he clearly said the problem with the statute was the lack of fair notice. And that's a Fifth Amendment issue, and that doesn't go away. And if you adopt the government's position, how are you going to instruct the jury? What guidance does, by its nature, give the trial judge to instruct the jury? My position is none. The government's position here, they rely on Barrett. Barrett is not a good case. Barrett does not discuss Leocal versus Ashcroft. It kind of finesses this sort of by its nature language. And it's...
I'd like to go back to Judge Luce's question. If we decide the first case in the way the government suggests, how do we not decide your case, which comes to us in a different guise, in exactly the same way?
Well, I think the circumstances are different. Obviously, I'm arguing that the government's wrong. I mean, what else can I argue? I mean, I don't think that they've addressed the statutory interpretation, and I don't think they've addressed the Fifth Amendment issue. Also, the Barrett is inconsistent with at least three other circuit cases now, which have decided that the residual clause in 924C is unconstitutional. They applied the categorical approach. Barrett stands alone. Post-Amaya, there's now the 10th Circuit, the D.C. Circuit, and most recently, as you can see from my 28J letter, the 5th Circuit. They all embrace the categorical approach, and they all find the residual clause to be unconstitutionally vague. And I'm sorry.
We've asked you to assume that we're going to reject that view and then ask, so what's left of your case?
Well, I'm not sure that I have a clear...
You keep going. Okay.
I'm not sure I can give you a clear answer, but I think that the...
You should have thought of it.
I'm sorry?
You should have thought of an answer to that question. It's perfectly predictable that we would ask you that question.
I failed to make that prediction. What the position that we're taking here is nothing new. There are a considerable body of cases. They're cited in our responsive pleading or response to the government's objection to our request for a 2255 petition. They are cases involving contemporaneous misconduct, and those cases are all read with a categorical approach. The government is asking you to make a radical change, to go from a principle of statutory interpretation and an application which is 28 years old and which has been adopted by the majority of circuits, as I say, including at least 3 since the Maya. The doctrine of constitutional avoidance only comes into play if the statute has 2 plausible interpretations. I submit to you that what Barrett did was a stretch, and I think that Justice Kagan got it right in terms of how you interpret the language. Her interpretation is consistent with what the court said unanimously back in 2004 in Leocal. Look at what by its nature means, and that calls for an ordinary case, a categorical case approach, not a case-specific approach. And I just don't see how a judge is going to be able to instruct a jury if the court embraces the government's view in this case. And I do remind you, I realize you perceive it as an evasion, but I do remind you that this is up on in a Moore situation. We're seeking authorization to pursue a successive writ, and the standard in Moore is if we have made a prima facie showing that we have a valid constitutional claim, which I submit that we have. The statute here is written exactly the same as 16b, and we're asking you to apply a rule of construction which has been long embraced. Then we made a prima facie case, and the case ought to go back to the district court in New Hampshire for further consideration.
So having said that, you have not been able to answer either Judge Lynch's question or mine. What happens if we adopt the government's point of view?
Well, I think that she's probably denied all relief. I mean, this is a successive writ, and it's a constitutional claim that didn't exist when she was convicted and sentenced in 2009. This closes the door. And the reason that Moore came down the way it did last September of last year was because if there is a claim which has been acknowledged, a right which has been acknowledged by the Supreme Court, subsequent to the original adjudication, the defendant has the right under 28 U.S. Code 2255H to come back. And if he or she makes the prima facie showing, which I submit that we have, then he or she is entitled to relief. So in this case, I don't think the court ought to make the decision based on the facts of this case that would close the door to my client.
I think we probably agree with you on your Moore take. It's just the problematic issue as to if we agree with the government. Like you said, you probably are not going to be entitled to relief because we'll be deciding the underlying claim against you. So that if we decide Douglas in favor of the government, then there's going to be precedent which...
That would be problematic to Elaine Brown. I guess I haven't been clear enough in making that point. I certainly urge you not to go that way. I don't think the law supports it, and I don't think that this case should be the vehicle to pursue that. It is clear that ultimately this issue is going to be resolved by the Supreme Court. I can't imagine. There's already a split in the circuits, and I submit that this is not the time to change course. If the Supreme Court goes the other way, if it embraces the dissent of Justice Thomas, that'll be a major shift. But Justice Thomas, on this issue, in terms of jettisoning Leocal, he specifically said the court would have to overrule Leocal, and Leocal is important because it's a case of statutory interpretation, interprets the same two provisions here, admittedly in a non-criminal case, in terms of, it's not exactly like this case, it's an immigration case, but the principles are there, and the statutory interpretation is there. And I urge you to...
Mr. Lang.
I'm sorry.
Thank you.
Thank you, Judge.
Good morning. Seth Aframe for the United States. So the question here is, how do we treat this problem in a second or successive posture? We've heard the merits of the case, of the underlying issue, discussed. I'm happy to discuss those further, but perhaps what I should talk about is the second or successive standard under Moore, and how does that apply?
No, we don't want you to repeat the Douglas argument. We do want you to address whether, if we were to adopt the government's position, there's anything left of this case. And as part of that, you should, if you choose to do so, tell us whether we have to get into the Moore issue or whether it can be avoided.
So I think you're asking me, if you rule in the government's favor and determine that a case-specific approach applies, then the error that has been asserted in the pending successive petition would have been necessarily rejected, and there would be no new rule of constitutional law that would then be appropriate to assert in the district court. So I think it would terminate the position of Ms. Brown and end the second or successive matter. I suppose the alternative question is, what happens if you rule in favor of Mr. Douglas? Should you then grant the second or successive? And I think that's a more difficult topic that I'd spend a minute talking about. So I think we have to consider, well, what is the point of the second or successive procedure? And my view of that, or the government's view, is that it is supposed to be a relatively mechanical matter. That is, the law, the new rule of constitutional law, should be generated through direct appeals or first 2255s in the Supreme Court, such that to get authorization, it has to be proven that at least arguably all the links in the chain necessary to make your argument exist from Supreme Court authority. And that's why I wanted to talk about Moore. Because why I think Moore was important to my argument is what the court held there was, yes, it had to be a prima facie case, and there was language that doesn't require absolute certitude. But what was discussed in Moore was all Supreme Court authority. And the question was, does the mandatory guidelines fix sentences? Because whether a sentence was fixed was very important to the Johnson analysis. And what the panel said in Moore is, we're pretty sure that Booker answered that question and said that it does fix sentences. We don't have to say we're 100% sure. We have to say we're pretty sure. That's enough to send it back to the district court. But what's important about that is not the pretty sure part of that. What's important about that is they were looking to the Supreme Court. So let's say...
So if we think DiMaia doesn't answer this question one way or the other, your position would be there is no Supreme Court precedent for petitioner to rely on.
Correct. And let me just say that at first blush seems terrible. Ms. Brown's never going to get her day in court. But that's not right. Because eventually that issue, as Mr. Lang just said, and I agree with, will be resolved by the Supreme Court. And that will be the moment, assuming it went in her favor, for the second or successive petition. Because now we're not asking courts of appeals and district courts to decide. What we heard in the first half hour here is a really difficult question. And that's really not appropriate on a second or successive petition. That's the whole point of AEDPA. Let's deal with these things through direct appeals, first 2255s. Then if there is a sea change in the law by the Supreme Court, we can fix those old cases. But we don't use those old cases to break the new ground.
So he says, look, I've made out a prima facie case under Moore. And your response is, no, you haven't, because it has to be under Supreme Court precedent, and there isn't any.
That's right, and so that leads to what I think is the hard question. Because the way our discussion here started is you asked me, well, what if we rule for Ms. Brown in the Douglas case? The Supreme Court still hasn't answered that critical question. Is there an ordinary case analysis? Is that applied when you have a statute that uses a residual clause in a real-time context as opposed to a retrospective context like in the ACCA, like in 16b?
And you don't think it would require some tweaking of more? He does have circuit precedent from other circuits, 3 of them now, in his favor. Moore seems to be a little flexible about whether it has to be the Supreme Court that announces.
So I read Moore several times, obviously, for this, and as I went back, I was struck by it's Booker that they're talking about. They are not saying there's this hodgepodge of circuit authority out there about this. They're saying we do think Booker answers it. We don't have to say we're sure the government made some kind of argument about departures and maybe there's something to that. We don't really think so. But we'll let the district judge handle that in the first instance. But the core of what's being discussed is this is what we, the panel, think Booker means. Not what the 11th Circuit said about it, not what even we said about it. It's what did Booker say about it. And what's going to be missing here, no matter what you decide in Douglas, given the way that DiMaia came down with Justice Gorsuch saying, I'm waiting for the case, we're not going to know what they think about this problem because it hasn't happened yet. And that's not to say that Ms. Brown is not going to get her day. It's just not yet. And that's important to remember. That's what the whole second or successive concept, I think, was designed to achieve again, which is not to let these issues, because what's going to happen if you sent it, let's assume you didn't have Douglas, and you said, well, it's a tough call, we don't know, let's send it down to the district judge. Now a district judge in this posture is going to be making that decision. That's not really what we want.
How many years has she served on her sentence, and what is the term of her sentence?
She has served, it was in the mid-2000s, so we're at the 12 to 14 year time. She got 360 months on, she got 420 months total. 360 months of it was on the 924C. What would happen at resentencing in this case is hard to know. Let's assume.
No, I'm just wondering whether the Supreme Court will resolve these issues before she's out of jail.
They will. She has a long sentence left. So that's the core of, I mean, I understand my posture, some of the things I might have talked about if we didn't have Douglas, I'm not going to talk about today because you've discussed them already. But my focus today really is on, as you deal with this case, consider what's required under the second or successive standard. My point is, I think Moore is the authority. It looks to the Supreme Court. They had Supreme Court authority to look to get the question mostly answered that they needed to answer. You don't have that. You don't have that luxury here. You have a very challenging question, and that's all I need to prove today in this posture. Sarah? Your
use of the term luxury strikes me as maybe not quite right.
Well, thank you for your time.
Thank you.
All right. Today is number 181129, United States versus Ishmael Douglas.
May I reserve 2 minutes?
Yes, certainly.
Thank you, Your Honor.
I wasn't certain if that was a Longhorn victory sign or a 2-minute request.
It's where I hold my cigar.
Could you speak up just a bit?
Yes, I will. Thank you. May it please the Court. With the government's concessions in this case, there remains, it appears, a single issue, and it's one of statutory construction, involving Title 18 United States Code Section 924C3B. The question appears to be whether this Court is bound by the holdings of the United States Supreme Court, United States versus Johnson, Leopold versus Ashcroft, Sessions versus DiMaia, and the weight of other authority across the country, to apply a categorical approach and not a fact-based or circumstantial-based approach to determine whether a Hobbs Act conspiracy is a predicate crime of violence under Section 924C3B. When Congress amended Section 924C in 1986, it directly adopted the specific language of Title 16B, that definition of crime of violence, into the 924C part of the Armed Career Criminal Act. Courts have held that construction of one guides the construction of the other. Leopold and DeMaia have specifically held that the categorical approach applies to the identical 28 words that are present in Section 16B and 924C3B.
We have an interesting problem here, and I understand the thrust of your argument, but in fact the categorical approach was a judicial construct, correct, as opposed to a statement of what the Supreme Court thought Congress intended. It was a construct meant to avoid certain constitutional problems, and it's certainly well within the purview of the Supreme Court to construe a statute to avoid constitutional issues.
Well, Your Honor,
so the canon of like language reaches like results perhaps has not come up in this precise context before.
Perhaps that is true, Your Honor, but we'd go back to the idea of the categorical approach being a construct. I don't think it was designed to achieve a purpose. I think that the categorical approach was the focused interpretation, focused on the language of the statute and what the statute's language itself required the court to do. I don't think they created it from whole cloth, and I don't think they were thinking about it as a...
I would never accuse the Supreme Court of doing it.
So you don't think there's any difference between looking back to what happened years ago in a contemporaneous case where all of the issues are in the complaint against your particular defendant? And why should that be?
I would suggest, Your Honor, that it's really a distinction without a difference because the language of the statute calls for it, and the experience
of... That doesn't answer my question, I don't think.
The experience of Title 16B shows multiple instances where this language has been used in terms of determining whether a present case, not a past case, but one that's actively before the court, qualifies as a crime of violence under that language.
You would agree this circuit has not held that?
I would agree with that, yes, Your Honor. But I do suggest that DeMaia expressly, in the majority opinion, that's adopted, at least by the Chief Justice, and I'm arguing that Justice Gorsuch adopted the portion of that.
But he said the question was open.
But he did, but he also adopted Part 1 of Justice Kagan's opinion that applied the categorical approach. So he didn't, undermine that part of it.
But didn't he also say that the government had failed to present any argument?
Right, he said it's a waiver.
Yes, well, waiver is a very live argument in this case as well, Your Honor. We won't get there just yet.
Nicely done, but let's stick with DeMaia and what it means.
Okay. But I think that Justice Kagan dealt with that in terms of whether or not it only had a backward approach look or whether it could be used in a present case. And I think that she found that it was appropriate either way. Certainly, you now have at least two circuits, the 10th in Solace and the D.C. Circuit in Ishitu that have adopted the categorical approach in 924C C3B cases.
But in both of those cases, wasn't there circuit precedent that had already concluded that, and therefore the question was whether DiMaia compelled a different result than, and our question is different since we have no circuit precedent on the point?
Well, Your Honor, I would point to the court to Taylor and Turner in this circuit. Turner, while it doesn't expressly discuss the topic, it's very clear, and I think it would be incorrect to suggest that it doesn't, adopt a categorical approach to determining whether a Hobbs Act conspiracy was a crime of violence under 924C3. It finds that it was. It utilized the residual clause with language that if you look at the underlying crime that was conspired to, and if that's violent, well then the conspiracy tags along.
Properly instructed jury answer the question very well and get around any of the other problems which might exist?
Well, Your Honor,
in a contemporaneous case.
We would suggest that in and of itself, the jury instruction, if the court were to adopt the government's point of view, we think that it doesn't eliminate the vagueness in the language of 924C3B that would have to be presented independently to the jury for them to resolve. First, you'd need the elemental instructions on the underlying predicate offense, in this case Hobbs Act conspiracy. Then you'd need to instruct the jury on the language of 924C3. And how do you deal with the language that the United States Supreme Court has time and time again says when you talk about an offense, it's the general offense. When you talk about by its nature, it means what, the ordinary case is. But if you eliminate the ordinary case piece and turn your attention to the specific facts of the case before the court said it was a two-pronged problem, with the ordinary case being one of the troublesome prongs. And once that's gone, I'm trying to understand the difficulty of a jury just simply looking at the case before it and making that decision about the violence and risk. Well, Your Honor, we'd agree that if it was in isolation, the evaluation of a substantial risk, juries do that all the time. But giving the question to juries doesn't take away the ordinary case language that's present in the statute the court would have to interpret them on. So you're really shifting.
I'm sorry, you mean by its nature?
Yes, the offense.
Equivalent of the ordinary case?
Yes, and also the word of offense that points to the statutory creation of the offense, and the by its nature, which talks about.
I want to go back to Judge Thompson's point, because it seems to me that the government has an argument that, in fact, you're avoiding a Sixth Amendment problem in a contemporaneous case by submitting the issue to the jury and not having a judge take the issue away from a jury. What's your response to that? 4 parts. First, if it is a question of law because of the ordinary case and categorical approach, then it's not a matter of fact. It's a question of law, so you're not taking anything away from the jury. That assumes the answer, so let's move on.
It does. Constitutional avoidance, however, Your Honor, you've got constitutional problems in adopting the government's approach. First, what Justice Kagan pointed out, that you should interpret the identical language in the statute identically and consistently where it's found. That's one problem. That's a canon of construction, and I do intend to ask the government about that, but there are exceptions to that canon. Yes, and another constitutional issue is that if you tell all of the people who are now sitting in prison that their 924C3 conviction, which was based on application of the categorical approach, that now they really had a right to a jury trial. In this circuit, you think we're going to have that problem when you've conceded that we've never so held? I think if you tell people from this circuit who have had those kinds of convictions, Mr. Douglas being one of them, that he was entitled to a jury trial on that issue.
He wouldn't have pled guilty despite the overwhelming evidence against him?
Your Honor,
I'm just trying to understand your parade of horribles if we go down the path the government urges.
well, I think there's more than just those. I think if you take their approach, I think you've broadened the idea of what's a crime of violence to an almost absurd degree. For example, a crime might be illegally crossing the border. Well, that's not a crime of violence. Well, if you illegally cross the border with a gun, okay, then do you give that to a jury and say, well, there's a, substantial risk that there could be harm to another person?
What's wrong with letting a jury decide that question?
Well, I don't think 924C was intended to cut a wide swath among all of these other substantive offenses, which by themselves clearly are nonviolent. But then when you introduce the gun, there's a prejudicial quality to that, but it's also almost impossible for the jury to distinguish if those are the facts that they have to evaluate. And it's not a fact-based approach if you isolate the gun aspect of this and get a determination without it. I mean,
but no judge would instruct the jury that a mere presence of a gun determines this as a matter of law.
But they would be given that evidence, and then they would be asked to evaluate whether there was a substantial risk of injury to another person or property by this alien who is illegally crossing the border with a gun. And I think
the jury instruction would first be, you have to make a determination as to whether the predicate crime is a crime of violence.
Yes, they would be given the elements of that predicate crime.
Yes.
Then they would have some sort of instruction under 924C3, A and B, force clause, residual clause. And I'm suggesting that the residual clause has been interpreted with ordinary case and substantial risk, and that would have to be part of the instruction given to them. It doesn't take it out of it just to call it a jury question.
I have a question. If we adopted your position, would that not open innumerable cases to being reconsidered where people say, well, I pled and I made a mistake. I obviously, this was not...
I think not, Your Honor, because I think the position I'm advocating has been the law, if not expressly stated. Certainly the district courts all apply it that way. It's the way it has been since Taylor. I think that the government's asking this court to engage in a high degree of judicial activism to essentially change the interpretation of this statute that's been applied and in effect for a significant time.
Thank you.
Thank you, Your Honor.
You have your 2 minutes. Counsel.
Good morning, Your Honors, and may it please the Court. John Taddy for the United States, along with Benjamin Block from the U.S. Attorney's Office in Maine at counsel's table. As several of these Court's questions were indicating, context matters. And here, the context is that the Supreme Court has only applied the categorical approach to recidivist statutes, like the ACCA and Section 16B, as a saving construction to avoid practical and constitutional concerns. It has never applied the categorical approach to a statute like Section 924C3B, which requires a determination based on presently charged conduct of whether a defendant used or carried a firearm during and in relation to a crime of violence. The Court didn't address the specific circumstances that exist for a statute like Section 924C3B. What my friend on the other side would like the Court to do is to basically airlift Section 16B into 924C3B without considering the context, without considering the unique factors of how the text of Section 924C3B exists in the remaining statute, and without considering the very weighty practical and constitutional concerns that were the feature of categorical approach cases dating all the way back to the judicial construction of the categorical approach in Taylor in 1990, then carried over to the ACCA residual clause in James, and then applied by a four-judge plurality in DiMaia to say that a case-specific approach in that particular case was not viable. With respect to DiMaia, it's not correct to say that that court held that a categorical approach was not viable for any language like that exists in 16b. And Justice Kagan's plurality opinion in that particular section relied on four different factors. As I believe Judge Stahl noted, one of those factors was that the government had not raised that particular argument in that case. It had not advocated for a case-specific construction, and therefore the court didn't deem it appropriate to consider it in that particular case. The second factor was those weighty constitutional concerns that would result from adopting a case-specific consideration. Justice Kagan didn't say that the doctrine of constitutional avoidance could not apply to save language like 16b's. She merely said that it would ping-pong the court from one constitutional problem to another because 16b in the criminal context is often applied to recidivist conduct. For example, illegal reentry offenses like 1326b offenses. And in that context, it would give rise to the very real Sixth Amendment concern of increasing a defendant's statutory range as a result of factors that weren't before the jury. So therefore, constitutional avoidance could not serve as an interpretive tiebreaker, is what Justice Kagan wrote in that particular opinion. She also noted that the text as best read in that particular circumstance in her plurality supported a categorical approach. But as the Second Circuit wrote in its recent decision in Barrett, in which 3 judges found that a case-specific approach was possible for this particular statute, the text doesn't necessarily need to be best read to support a categorical approach or to support a case-specific approach. All that's required under the doctrine of constitutional avoidance is that it's a plausible interpretation or a reasonable interpretation. And as the government wrote in its brief, and as the Second Circuit held in Barrett, it is certainly a reasonable interpretation to look at the language of Section 924C holistically and the language of 924C3B specifically and find that it is amenable to a case-specific approach. And I'd like to...
So when Justice Kagan said text as best read, you don't interpret that as part of the case holding?
No, not in that particular circumstance. She was addressing, and if you look at the way that the breakdown of the opinion went in that case, Judge Thompson, only 4 judges signed on to that particular part of the opinion that said that the language was best read in that way. As the panel indicated, Justice Gorsuch did not join that portion of the opinion. He reserved for another day in which the government had properly argued that particular point as to whether the statute would be amenable to a saving construction like a case-specific approach, but did not join that portion of the opinion. And of course, 4 justices dissented to the majority opinion in that case, striking down 16b. So no, that section in which Justice Kagan wrote the statutory language was best read was not a holding of the court. It was only joined by 4 justices.
Isn't 4 and 1 5?
Excuse me?
Isn't 4 and 1 5? 4 plus 1 is 5?
No one else joined. Justice Gorsuch did not join that portion of the opinion, Your Honor.
Okay.
He wrote separately to say that he wasn't in agreement with Justice Kagan's plurality opinion there, that this was not that this particular statute 16b was not amenable to a case-specific construction. But as I mentioned briefly before, the language, the text itself, if we can consider that for a moment, does support a case-specific application. My friend noted that the word offense suggests that a categorical approach is required. That's not what the Supreme Court has said in cases like Nijuan and Hayes. In both of those cases, the court adopted a case-specific reading of the term offense and said that it's capable of multiple constructions. The word involves also suggests a case-specific inquiry that looks at the facts of the offense. If you take a step back and look at the larger statutory framework, you look back at Section 924C1A, which talks about any person who during and in relation to any crime of violence uses or carries a firearm, or in furtherance of any such crime, possesses a firearm. That is a fact-based inquiry that's determined by a jury. there's no objection to that, or there's no controversy over that in this case. In a 924C case, the jury is always instructed to determine whether or not the underlying offense, in this case a conspiracy to commit a Hobbs Act robbery, actually occurred, if the defendant was guilty of the elements of that particular offense. Then the jury needs to make a determination of whether there was a firearm possessed in furtherance of that crime, or if the person used or carried a firearm during in relation to that crime. The additional element that would be required under a case-specific approach is, rather than for a judge to make a categorical determination of whether every Hobbs Act conspiracy involves a substantial risk of physical force, the change would be that the jury would determine whether the offense by its nature involves a substantial risk of physical force.
So you get around the Sixth Amendment issue simply by the judge instructing on the question.
Yes, that's correct, Judge Stahl.
Having said that, the government has come to this position lately, as I understand it, as these cases have evolved. What was your position earlier on this?
Well, prior to DiMaia, the government's position was that 924C3B required a categorical approach. And the reason for that, I'm sorry, Judge Stahl, looked like you were... But quite honestly, the reason for that is part of the sort of unavoidable creep that has occurred, starting with Taylor in 1990, of both the government and the courts assuming that the categorical approach applies to anything that sort of walks and talks and looks like the ACCA residual clause. We assumed that it applied to similar type language. We didn't have too many problems for a while because it seemed like most violent crimes were encapsulated within that categorical inquiry under the ordinary case approach. It crept over to the ACCA residual clause in James, and until DiMaia struck down 16B, and the court unequivocally and clearly stated that the ordinary case approach, when coupled with a risk assessment, is unconstitutional, required both the government and the courts to reevaluate their prior assumptions that the categorical approach applied to this language. That's what the Second Circuit did in Barrett. There the court did have binding precedent, holding that 924C3B required a categorical approach. And nonetheless, in Barrett, 3 judges unanimously agreed that DiMaia was a complete game changer. And that is, in a long-winded answer to your question, Judge Stahl, is what required us to reevaluate our positions, to really take a critical look at Section 924C3B and how it worked and its mechanics. And we recognize that there's no reason to apply this prophylactic categorical approach that came up to address the practical problems of dealing.
The Second Circuit also, sorry to interrupt you, but in truth I'm not buying much of it. The government made policy choices much earlier that it was willing to go along with the categorical approach. Now it is making a different policy choice. To me, the government's policy choices are less important than what Congress intended. The Second Circuit seemed to say, well, our law is that because conspirators basically agree to the elements of the underlying crime, as a matter of law, a conspiracy to do a Hobbs Act armed robbery will result in a finding that this is a crime of violence. I'm rather uncomfortable with that. It seems to be at tension with the notion that we will give this to the jury to decide. Your brief does not seem to espouse the Second Circuit view. I think there's a footnote where you say, because it's fact-specific, it will have to go to the jury to make the determination. Is that the government's position here? And is that different from the government's position in the Second Circuit?
The government's position here is that the Second Circuit's alternative holding that conspiracy to commit Hobbs Act robbery categorically qualifies as a crime of violence under Section 924C3B is not correct. The only viable construction of the statute is a case-specific construction. The statute quite simply can't have 2 different meanings at the end of the day. It either has to be required to have a case-specific construction or it's required to have a categorical construction. The difference between 16b and 924C is, of course, that they're different statutes. And though the text of the residual clauses is the same, as we've been discussing, they have different contexts, they have different purposes.
Okay, so let's explore the implications of the rule, which is contrary to the common statutory construction canon that like language should be interpreted in like manner. Mm-hmm. Okay, let's assume that we are to adopt the point of view that you have. What are the limiting principles that we should articulate for why this canon does not apply here?
I think there's at least two, Judge Lynch. One is, and I would encourage the court to consider again cases like Nijuan and Hayes, where the Supreme Court has said that like language, in that case, the definition of an offense, is capable of different interpretations based on the context that the particular language exists in. Two other cases, and these aren't cited in the brief, but I believe they're responsive to your question, and I'd be happy to submit a 28J after, are cases like Johnson 1, also known as Curtis Johnson, which deals with the definition of physical force, and Castleman. In Johnson 1, the Supreme Court said that physical force in the context of the Armed Career Criminal Act means violent force. And in the context of Castleman, for the definition of a misdemeanor crime of domestic violence, physical force did not require physical force. And the reason for that, as Justice Sotomayor, articulated in her opinion in Castleman, was that the statutes have different purposes. They have different contexts. And to require the violent force felony requirement from Curtis Johnson and import it into the misdemeanor crime of domestic violence definition would totally obliterate the meaning of the statute and wasn't necessary whatsoever. So in terms of a limited construction, I would say context is the first consideration in determining whether or not like language is capable of different interpretation. And two, in this particular case, the doctrine of constitutional avoidance, which in many ways is a higher...
I was going to ask you, does your outcome turn on the doctrine of constitutional avoidance?
I wouldn't say that it necessarily turns on it, Judge Lynch, but it's definitely a weighty factor in the government's favor here. We do believe that if you sort of cut out all of the assumptions about language that looks like the ACCA and the recidivist, and consider the recidivist context, that the best reading of the 924C3B and, quite frankly, 16B language is a case-specific approach, but the doctrine of constitutional avoidance certainly pushes it over the edge because the Supreme Court has made it quite clear that otherwise an ordinary case approach is unconstitutional, and this court would be required to strike down the statute if the statute is not amenable to a case-specific construction. And what the Supreme Court has said in terms of constitutional avoidance is that any reasonable interpretation is required. And
Okay, the two constitutional issues are the vagueness issue and the Sixth Amendment issue, and if we were to adopt your construction, we would avoid both of those?
There is, I would suggest a slightly different framing, Judge Lynch, which is that the Sixth Amendment issues are not in existence in the 924C context because it only deals with...
But if we were to adopt the categorical approach in this context, would there be a possible Sixth Amendment problem?
I don't think so under cases like Almendarez-Torres, for example, and Apprendi and Elaine, which say the fact of a prior conviction doesn't raise Sixth Amendment problems. So here, I guess you have the fact of a present conviction. If I may finish answering that question. We don't have a prior conviction. We have a current conviction. But what underlies that, of course, is the entire sort of force of the contextual argument the government is making, which is that there's no reason to resort to this unnatural categorical construction. The Supreme Court has said time and again that the usual way that we make evaluations like what offense involved a substantial risk or how much risk or whether the government has proved its case beyond a reasonable doubt, for example. Determinations like that are left to a jury, and there's no reason to resort to this unnatural judge-made construction in this case.
Thank you.
Thank you.
Mr. Billings.
Thank you, Your Honor. Your Honor, it isn't just in prior cases and in DiMaia that the government has taken the position that categorical approach applies. They did it in this case. In the district court, they specifically said their counsel told the court that they agreed that the ordinary...
And he's just argued, well, DiMaia hadn't been decided at that point. Once DiMaia came out, we realized that there was an issue here.
But
normally, we would let the government change its position in light of a Supreme Court case.
But that court case, the ruling authority and judged by Judge Roberts, making 5, utilized the categorical approach, and it didn't provide a basis for saying that that notion was under challenge. In fact, that's expressly stated in the Ishitu case from D.C. that DiMaia provided no basis for challenging the application of the categorical approach. And it isn't just that Judge Kagan said that...
Do you think DiMaia mandates application of the categorical approach to this problem? Or is that
yes,
going a little far?
I think it's precedent that this court, its role would be to follow and not to lead on this question. We would suggest that since 16B and 924C are sort of symbiotically bound, that interpretation has to follow. But the waiver is a significant principle that is applied routinely to defendants who try to change their argument in the middle of a case, and now the government comes forward having argued exactly 180 degrees the opposite in the district court, and now they want to change that point of view here. Thank you, Your Honor.
Thank you both.